Chair and the Vice Chair and all of the members, thank you so much for hearing testimony. My name is Jody Neal. I'm here on behalf of myself. I am representing myself today. I'm an attorney in the opioid litigation representing more than 45 counties in Texas.
But you're here testifying, Jody, just today on behalf of yourself?
That's correct.
Okay, and your position on the bill?
Definitely against.
Okay, go ahead.
As I said, thank you, Chairman. I am here as a lawyer representing more than 45 counties in Texas. I'm happy to list them once I find my list. B. Burnett, Cass, Cook, Coryell, Dallas, Delta, Dimmitt, Ector Falls, Fannin, Freestone, Grayson, Hopkins, Houston, Kendall, Limestone, Marion, McMullen, Melam, Nacogdoches, Orange, Panola, Parker, Potter, Robertson, Shelby, Trinity, Van Zandt, and Wood counties. What I have learned from representing all of these counties is that when Texans are united in a mission, we can do a lot of good for the people of Texas. Most of these counties that I represent are typically red counties, and I'm their lawyer, and I go to them and we talk about their problems, having these opioid problems. And what we've seen is that we can come together and we can do something good for the people of Texas, and that's what's happening here in the opioid litigation. I'm very concerned about open courts. The way that I read the open courts provision of the Texas Constitution, which is Section 13, it says that the legislature may not abrogate the right to assert a well-established common law cause of action unless the reason outweighs the litigant's constitutional right to redress. And I have not heard anything here in the committee that outweighs the right of the counties to bring this lawsuit. For me, as a Texan, I feel like this is a Seventh Amendment attack on the counties. The counties have to have the right to take the action that they need to take. Texas is so vast and so different. You can't expect a singular state agency to be able to abate all the public nuisances that can come about. It just is not going to happen. The counties, like a person in Texas, have this right because it's an important way to bridge the gap between when the legislature meets and the real-time, everyday problems that counties face. The legislature meets every 2 years. The counties are working all the time. County commissioner court meetings happen every week, every other week. And this is a useful tool, a very important tool that the counties need to take care of their business, especially when the legislature is not in session. Finally, the Supreme Court has upheld public nuisance. We went up on 91As, and the Supreme Court gave us our case, and we litigated it. The Supreme Court blessed our case by allowing us to continue. And certainly, that should say volumes here in this committee. Thank you.
Thank you, Jody. Members' questions. Well done on the timing. Vice Chair
Thank
Johnson.
you.
Thank you, Mr. Chairman. I just want to kind of go back and elaborate on a couple of points you made. So I think it's important that, to your point, that the Supreme Court of Texas had a chance to do a thorough legal review in the opioid litigation and determined that public nuisance was a valid and appropriate cause of action to be utilized in that litigation.
Yes, you're correct.
And I think that's important for this committee to keep in mind. I don't think it could be said that the Texas Supreme Court is the liberal bastion of a judicial handling of things, and the fact that they recognize that this is an important cause of action and long-standing in the Texas law is important. The other thing I wanted to ask you is, and just highlight with you, is in your work with all of these counties throughout the state of Texas, it's the counties that bear the brunt of the expense of having to deal with the harms caused by public nuisance and the injuries, as Craig Island so eloquently talked about, right? And in your work with them, they've expressed the real struggles and financial hardships that they have in having to deal with these problems on their own without opportunity of redress.
That's correct, Vice Chair. We hear over and over again that, and where you see it is in county commissioner court meetings, you see the behavioral health teams come together, or you see the jail teams come together, and everyone is just crushed by the weight of the need for all of these services. And finally, there's a light at the end of the tunnel. Finally, as you know, 70% of the settlement monies are being put into abatement funds. Finally, they're looking at ways that they can fill out these applications and have access to these abatement funds so that they can set up their own drug courts, so that they can equip their first responders with Narcan, so that they can even fortify their district attorney's offices to prosecute these cases. They feel the weight of the epidemic, and they're looking forward to the opportunity to finally be able to solve this problem with money that's not the taxpayers' money. It's the defendants' money.
The opioid litigation really genesis from county litigation.
That's correct.
It didn't start at the state level.
No, the state, I believe, sued 2 defendants. One went bankrupt and one settled as part of the county's deal.